This is Dr. Martha Harris, and today's presentation is The Influence of Litigations on Special Education. This presentation includes audio that reads the slides. Therefore, closed captioning will not be used. Lecture agenda: Catalyst for Change, Litigations Before IDEA, Courts Interpret IDEA, and Summary. What needed changing? Previous discrimination included exclusion and ineffective or inappropriate education. Students were often misdiagnosed, and there was bias in testing instruments and bias in intent. The one thing we can be sure of is change. Yale said it best in 1998. The process of change is never finished. Legal influences on special education are not fixed or static, but fluid and dynamic. Cited by Heward in 2000. Bringing about change, litigations. Litigations address questions concerning compliance with the law. Rulings reinforce the principles of the law and establish legal precedents. Establish legal accountability and hold all accountable for compliance with the law. Why change? It all started when parents demanded a good education for their children. Litigations shape education before IDEA. Landmark litigations shape special education. Brown versus Board of Education, 1954. The issue was declared separate but equal, unconstitutional. The finding was basis for future ruling that children with disabilities cannot be excluded from school. Pennsylvania Association for Retarded Children, Park versus the Commonwealth of Pennsylvania, 1972. The issue was the right to FAPE for students with mental retardation. Finding: signaled a new era for special education and set the stage for Public Law 94-142. Mills versus the Board of Education of the District of Columbia, 1972. Issue: the right to FAPE for all students with disabilities. Finding: reinforced the right to a free and appropriate public education for all students with disabilities. No for the test. Litigations shape special education continued. Hansen versus Hobson, 1967. African American students disproportionately represented in the low track. Finding: standardized tests were biased. Tinker versus Des Moines School District, 1969. Issue: students protesting Vietnam War were expelled. Finding: students have constitutional rights separate from parents while in school. No for test. Litigations shape special education continued. Diana versus California State Board of Education, 1970. The issue: misclassification of Mexican American and Chinese American students based on culturally biased tests and not tested in English versus native language. Finding: California must test students in their native language, must test students with culturally appropriate test instruments. State forced to reevaluate all students in special education who were Mexican Americans or Chinese Americans. Covarrubias versus San Diego Schools, 1971. The issue: misclassification hurts the child. The finding: family awarded damages to be paid by the school district. No for test. Summary of issues pre-IDEA. Across the nation, the courts were addressing the issues related to special education for students with disabilities. Students have rights, including the right to a free and appropriate public education. Courts were holding states and districts accountable for non-discriminatory evaluations of students with disabilities. No for test. Litigations Interpret IDEA. Litigations hold schools accountable. Larry versus Riles in California, 1971 through 1979. Issue: African American students disproportionately represented in special education. Finding: standardized tests were biased. Cannot use these tests with African American students. State ordered to reevaluate all African American students in special education. State ordered to monitor and eliminate disproportionate placements of African American students. Pace versus Hannon, Chicago Schools, 1980. Issue: African Americans disproportionately represented in special education. Finding: standardized tests were not biased. Ruled in favor of the school district. No for test. Litigations hold schools accountable. Continued. Matty T. versus Holiday. This happened in Mississippi, 1975 and 1981. Issue: state not meeting the requirements of Public Law 94-142. Finding: courts ordered district to redo evaluation procedures and hire outside help to do assessments. Frederick L. versus Thomas. This was in Philadelphia, 1976. Issue: serving too few students with learning disabilities. Finding: courts order district to do massive screening to locate and serve students with learning disabilities. Luke S. and Han S. versus Nias et al. In Louisiana, 1981. Issue: failure to evaluate students in a timely fashion. Serving too few students. Finding: courts order state to hire more assessors and retrain all current assessors. No. Litigations Interpret IDEA. Raleigh versus Hendrick Hudson School District, 1984. Issue: free and appropriate public education, FAPE. Finding: school districts must provide those services that permit a student with disabilities to benefit from instruction. Irving Independent School District versus Tatro, 1984. Issue: defining related services. Finding: if a health service can be performed by a trained person other than a physician, schools must provide that service. Smith versus Robinson, 1984. Issue: attorney fees. Finding: parents are reimbursed legal fees when they win a case resulting from special education litigation. No for test. Litigations Interpret IDEA continued. Burlington School Committee versus Department of Education, 1984. Issue: private school placement. Finding: in some cases, public schools may be required to pay for private school placements when the district does not provide appropriate education. Honig versus Doe, 1988. Issue: exclusion from school. Finding: students whose misbehavior is related to their disability cannot be denied education. Timothy W. versus Rochester, New Hampshire School District, 1989. Issue: free and appropriate public education, FAPE. Finding: regardless of the extensive or severity of a student's disability, a public education is the right of every child. No for test. Litigations Interpret IDEA continued. Zobrist versus Catalina Foothills School District, 1993. Issue: paid interpreter at a Catholic high school. Finding: paying for a sign language interpreter does not violate the constitutional separation of church and state. Doe versus Withers, 1993. Issue: FAPE, free and appropriate public education. Finding: teachers are responsible for the implementation of accommodations specified in the student's IEP. Schaefer versus Wiest, 2005. Issue: appropriate education. Finding: in legal decisions, parents, not schools, must prove their children are not receiving an appropriate education. No for the test. Summary of issues post-IDEA. Courts were holding states, districts, and teachers accountable for the following mandates of IDEA: free and appropriate public education, FAPE, the 6 principles of IDEA. Courts reinforced school responsibilities to provide FAPE and to address student behaviors. Courts interpreted the definition of related services and the school's responsibilities. Court defined options for parents if a school district does not provide an appropriate education, including burden of proof and financial responsibility. No for test. It's a new millennium. with a new paradigm. Because we have new values for our students, we have a brighter future for our students, which include educational rights, individual first, quality of life, use technology to provide opportunities, valued as an individual, and full citizenship. References: Hallahan, Kaufman, and Pullen, 2009, Exceptional Learners, 11th edition, Boston, Massachusetts, Pearson. Eward, 2009, Exceptional Children, An Introduction to Special Education, 9th edition, Upper Saddle River, New Jersey, Merrill. Smith, 2010, Introduction to Special Education, Making a Difference, 7th edition, Boston, Massachusetts, Allen and Bacon. Taylor, Smiley, and Richards, 2009, Exceptional Students Preparing Students for the 21st Century, Boston, Massachusetts, McGraw-Hill. Turnbull, Waymeyer, 2010, Exceptional Lives, Special Education in Today's Schools, 6th edition, Upper Saddle River, New Jersey, Pearson, Merrill, Prentice Hall. This presentation is copyrighted by Dr. Martha Jane Harris, 1997, 2000, 2005, 2010, 2017. Thanks for listening.